You, Senator Wright. Senator Canavan.
Thank you, Mr Acting Deputy President. And I just want to start by saying I think one of the most unfortunate tendencies of some on the other side of this chamber, some, not all, is the propensity or almost reflection, the reflective instinct to question the motives and intentions of people on this side of the chamber. I personally think all of us come to this place with good intentions. I think all 226 elected members of parliament, including the 76 in this chamber, have come to this place to try and make this country a better place, to try and provide for all Australians, to try and to do so in a way consistent with their own philosophy and values. And now we will often disagree, and rightly so, disagree on those values and the philosophies and the ways and means of achieving those objectives. But I think we'd be put on a better starting place if we actually all accepted that we actually do want to make this country a better place, and we do have good intentions. Now, the effects of our policies might not accord with those intentions. The wisdom of what we want to do may be incorrect, and it's right and proper for people to try and point that out. But a number of speakers on this bill have not sought to question the impact or the effects of the bill, but have actually sought to question the intention behind it, that there's some notion that we are doing this not because we think it is good and a proper policy, but because we are just simply mean-spirited individuals. And look, Senator Wright, who has now left the chamber, but Senator Wright, I think I'm a good person. I try and do good in my life. I'm sure I'm not always successful at that, but I try, and I do believe Senator Wright is a good person as well. And I think everybody here are genuinely good people, because the reason this bill is being put in place is not in any sense a vindictive or, in the words of Senator Wright, mean-spirited policy. It's simply an adjustment to the way we pay social security at the moment. There's always been provisions in the Social Security Act to restrict payments to those in confinement. Indeed, I'm informed that since 1908 there have been provisions in social security law that restrict payments to persons undergoing psychiatric confinement. Currently, the 1991 version of that Act restricts certain social security payments being made to persons who are in jail or psychiatric confinement following being charged with an offence, and there have been these similar provisions since at least 1947. So this is just simply an adjustment to provisions that already exist in our law that have persisted through governments of various colours and changes, and we have a very specific instance here of payments being made to individuals that are in confinement. And I accept at the outset here that people could disagree on these adjustments, but again, make the point that these are not being made in any sense in a mean-spirited way. They will, in fact, affect 350 people currently in Australia, and if they are put in place, around 50 per year, depending, of course, on convictions, will be affected going forward. So not an enormous number of Australians, but of course, for those individuals affected, not an insignificant issue. The bill would save around $30 million over the forward estimates. Again, not a substantial amount of money in the context of what would it be, more than 1.2, perhaps close to $1.5 billion budget over the forward estimates. But again, the reason we're making this change is not because of the money, it's not because of the savings, it's not because anyway there's some vindictive notion, it's because it's an adjustment to properly reflect who, and particularly which level of government, should be responsible for the rehabilitation of individuals that are under confinement. And if I go to that, these 350 individuals that are currently in confinement for serious offences are the responsibility of the state governments. They have been confined because they have been convicted of an offence, and in this case are also mentally incapacitated, so are in some kind of psychiatric confinement. They are the responsibility of the state governments, not the federal government. Indeed, that goes for other prisoners under confinement not in psychiatric institutions. They are the responsibility and care of our state governments, and that has always been the case. As the Department of Social Security provided evidence to the committee that was established for this bill, the department stated that, and this was regard to social security payments generally, they stated these payments should not be made where a person is confined under state and territory law and their basic needs such as food and accommodation are being met by the state and territory, as is currently the case for those in prison. Corrections, health and residential mental health services are a state and territory responsibility. It's very important to focus on that point, that why do we provide disability support pensions, which are often the ones in question here in this case? Why do we provide that pension to individuals in our community? Well, we provide that pension to let them, to allow them, to give them the resources to look after themselves and particularly to fund their food and accommodation costs. There are a few things you need in life. You need food, you need accommodation, you need clothing, you need your basic health care and education needs looked after. A few of those things aren't looked after by state governments through the provision of public services, particularly food, accommodation and clothing. And so we provide a pension, a disability support pension, or in other instances other forms of pensions, to help people provide for those services. Now that's why we provide the payment. It's set, and I don't have the number it's set at, but it's in the hundreds of dollars a fortnight it's set at to help people provide for those costs. That goes to individuals who largely, of course, are not in confinement and have to meet their food, accommodation and other costs. People who are in confinement, incarcerated or in a psychiatric institution, clearly often don't have to pay for their food, accommodation and clothing costs. Indeed, the practice is that those services and goods are provided by the state governments. So a state government will provide someone who is in psychiatric confinement their food. They'll provide them usually with standard issued clothing, and of course, by definition, they provide them with their accommodation. So these people don't have those extra costs that an individual would outside of confinement in our community. So the question has to be asked then, why is it fair to provide somebody in our community that, yes, may have a mental health disability, but any kind of disability that prevents them providing for themselves, with a certain level of payment? They have to meet all of their essential and non-discretionary costs from that payment. Why is it fair then to provide that payment and then provide someone else who is in confinement with exactly the same perhaps disability, but has their needs and care taken care for them by the state? Why do they get exactly the same payment then than another person who has a lot higher non-discretionary costs than that person in confinement? That's an anomaly. It's a clear anomaly, and we can disagree over how we might want to rectify that anomaly, but it is a difference. It's a clear and definable difference between how two people, both with disabilities, one that's in confinement for in this case, conducting a serious offence, another that clearly hasn't, but that person who has committed a serious offence is actually advantaged relative to the person who hasn't, because they have a bunch of costs looked after for them, and then we give them the same payment on top. Well, actually, in fact, often they don't receive that same payment on top, as the evidence to the Senate committee on this was provided. That would be clearly unfair to provide them all of that payment on top. They don't often receive that because, in evidence to the Senate committee, I think was chaired by you, Mr Acting Deputy President. It was a Senate committee by the Community Affairs Legislation Committee, so yes, it certainly was chaired by you, into this bill. We found, or the chair found, the committee found, that in many instances state governments are actually charging people in confinement for their food, accommodation and other costs. So I don't disagree with state governments in doing that, because, as I said earlier, the alternative would be to provide somebody in confinement with much more resources than someone not in confinement, and that would clearly be unfair. So to rectify that, the various state governments do often charge individuals in confinement, or I suppose the word would be dock their pensions to cover these costs that for the goods and services they provide them. So in the case of Victoria, in the past they have charged people in a mental health facility around 75 to 80% of their disability support pensions. The committee, and I also note here on page 12 of the committee report, that the committee notes that in jurisdictions where a person was paying 85% of the disability support pension to the mental health institution, that person will be left with a maximum of $63.45 per week. As I said, I'm not arguing against the practice of state governments, and sorry, also the Queensland government reported that after their deductions, mental health consumers have around $42 per week after the deductions made by the Queensland government. So one consequence of this bill clearly will be that those individuals in confinement won't have access in Queensland, in my state, to that $42 per week. The question comes then, who should provide that? Now, I don't disagree that people in confinement deserve some allowances to cover certain incidental expenses. Indeed, my understanding is that is often a practice with people in confinement in state jurisdictions, not people in non-psychiatric confinement, incarceration. They're often provided a small allowance to help pay for various incidental costs, and there's often shops and those things that they can use that money at in those facilities. That is, of course, provided by state governments. They provide inmates with those allowances, and they set those allowances according, obviously, to the needs of the inmates in a particular correctional facility, the goods and services and the prices charged in that facility, and they are in the best situation to judge what that potential allowance should be. So what we're arguing about here is not whether or not someone deserves a potential allowance, it's whether or not it should be funded through a disability support pension, which is a largely blunt way and not particularly fair way, at least to start off with doing it, or should it be the responsibility of the state government to provide for the people under their care. Now, I think, and I may come down, and this is a judgment decision. As I said, this is not something about whether we're intentioned in a certain evil or malicious way. It's a judgment call about which level of government should be providing that level of support. And it seems to me that, on balance, it's very clear that the state government are in the best position to do that. The state government or the territory government are in the best position to judge what the particular needs are of their inmates. We're not talking about a huge amount of money at something like $40 a week for 350 people, but it's something, of course, that they will be in a much better position as the carers and the people responsible for these people to make a judgment on. Now, I did note that in the various contributions from other senators, they reported that various state governments had made submissions to this committee and in other forums, saying that they were very concerned about the impact on the welfare of people in psychiatric confinement if this assistance was taken away. Well, they have within their powers, they have within their remit to provide for people. If they are that concerned, if the state governments in question here are in that concerned about the welfare of people under their care, they have the resources and the power to provide, I think, $42 a week for 350 people. I note that various state governments are in budget difficulties. We are here too. But $42 or something in that order for 350 people surely is not beyond the resources of a state government that apparently says it cares. Now, if it does care for their welfare, it can do an assessment of what is needed for those particular people and provide those payments itself. It would be a much simpler and more rational approach than the current approach is, where we provide people in confinement with a large sum of money and then have state governments have to make various deductions from that for their non-discretionary expenses. Now, I might just move to a couple of other detailed issues in this bill that have arisen. There has been some. No, I should say first up, actually, that the bill does make some provision to provide Commonwealth assistance to people in confinement in a psychiatric institution. Specifically, it makes an exception that a disability or any pension would continue to be provided in the instance where there's a period of reintegration occurring for that particular person, and that reintegration, that integration will be defined as a number of nights that person would spend outside of the mental health institution. So as someone is transitioning from a mental health institution to the general community, the Commonwealth Government will restart the pension payments, which seems fair and reasonable. Now, apparently the Department of Social Security did consult with state governments about whether that reintroduction should be done on a transitional basis, that a certain percentage of the pension is increased as they integrate more into the community, or whether it should just be either on or off. And apparently the feedback from state and territory governments was that it would be best just to make a straight definition that a certain number of nights, once that is hit, the full payment will be reintegrated. Again, clearly a matter of judgment, not something that, or something certainly that reasonable people can disagree on, but something, of course, in this position, in this parliament, we have to make judgment calls on. So that provision is there. That provision will also come into effect where a person is in a mental health institution for a reason not related to the offence that they were convicted for. So if they're there, obviously, because they simply cannot function in the community generally, the pension from the Commonwealth Government will continue and be reactivated. There have also been issues raised during the inquiry about the definition of a serious offence. This bill will only affect those that have committed a serious offence, and they have been defined as to include murder, manslaughter, rape or attempted rape, as well as other violent offences that are punishable by imprisonment for life, or for a period more than of at least 7 years. The reason, again, a judgment call has had to be made here. I don't think it would be fair to restrict payments to all people in a mental health facility confined for the reason of a conviction, particularly those that are convicted of offences with a term of imprisonment less than 7 years, because that goes back to the point about integration, that if they're in prison for a period of less than 7 years, then there clearly is a process of integration or rehabilitation that needs to start almost immediately, because it's not that far away before they possibly will do that, particularly given parole periods and those things. So there's very little value, or indeed there'd be very little saving of money to restrict payments for period in prison for a period of less than 7 years. So again, a judgment call has been made. Again, reasonable people can disagree whether that period is too much, too little. I certainly believe that we should not make it blanket across all people in an institution. So therefore, we've had to make a cut-off point at some point, and this certainly people that have convicted those sort of violent offences and those periods of imprisonment need to be properly cared for by the state governments and don't deserve to continue to receive Commonwealth Government payments. The final things I want to say is that I think there's this sort of emotional and overwrought commentary here on this bill. There's Senator Brown said earlier that these people don't deserve to be punished. Well, that's a very simplistic way of looking at this, because obviously people that have committed these offences, serious offences, including murder and rape, and yes, often, of course, in this instance, committed under periods of at least mental incapacitation, it's a very tricky issue, but do they not deserve to be punished at all? Do they just deserve to continue on with their lives as before? Well, well, clearly they're not, Senator Brown, because through you, Chair, clearly they're not, because we do incarcerate them. We do have laws that incarcerate people that commit. Yeah, well, they are confined for a mandatory period. Through you, Chair, through a mandatory period. So clearly there is decisions made at state government levels that there is some penalty to be paid. Now, again, this is a very difficult area, but it's not helped. This area is not helped when individual senators decide to question the bona fides and intentions of individual senators, as has happened in this debate. It's particularly unhelpful because these are very complex issues that do require considered judgment by all governments, and various state and federal governments have had to make these judgments over the entirety of our federation. This is another judgment being made by this government. It is a reasonable and moderate adjustment to our system that should be supported.
Thank you, Senator Canavan.